In this chapter, we examine how economic and political concerns both created and constrained legislation mandating accessibility in buildings. We'll start with a quick overview of the history and the rationale and also the limits of accessibility legislation. It turns out that early attitudes, pre-19th century, attitudes towards the disabled in the world and in the US in particular, were characterized by a kind of moralistic benevolence. Handicapped citizens were considered to be part of the so-called deserving poor. This changed in the 19th century with the growth of a liberal, individualistic culture. As Jonathan Young writes, because disabled people were unable to compete in the economy, they were spurned by society. However, this changed again in the early 20th century, motivated by war and industrial injuries, which changed the underlying logic of remediation. Early organizations like the Disabled Veterans of America, which was formed in 1920, lobbied for more support and protection of disabled war veterans. Now, a major milestone in the history of disability legislation was a standard issued by the American National Standards Institute, known as ANSI, Standard 117.1, back in 1961. And this standard for accessible and usable buildings and facilities relied upon research done by the University of Illinois that was actually supported by the Easter Seals Research Foundation. It contained rules and guidelines intended to allow people with various physical disabilities to get to enter, and use sites, facilities, and buildings. Remarkably, the guidelines contained in this standard have not really changed that much in all of the subsequent iterations over more than 60 years. However, it is important to note that these ANSI standards for accessibility were voluntary, and for that reason they were often ignored. Another milestone was the Civil Rights Act of 1964, which created a precedent. Now, it did not extend access to disabled persons, but it established this precedent that this sort of discrimination was against the law, at least potentially. And while ANSI 117.1 was just a voluntary standard, it did begin to influence various pieces of legislation, both at the federal and also at the state level, which started to require compliance with accessibility standards in limited subsets of buildings. For example, first in just federal buildings, and then after that in buildings subsidized with federal funds, which included a broader array of buildings, such as a lot of college buildings. And these actions culminated in the Americans with Disabilities Act of 1990, the ADA, which was signed into law by George H.W. Bush. And among other things, this piece of legislation mandated that all buildings, not only new buildings, but also existing buildings, be made accessible to people with various types of physical handicaps. The ADA was and still is controversial as an example of governmental intervention, since it constrains the freedom of property owners and their designers to do what they wish with their property. Yet the act, while revolutionary, is not quite as extreme as it appears. Politicians who were sensitive to this balancing between the freedom of property owners to do what they wish with their own property versus the rights of the disabled created limits or constraints that are actually built right into the ADA. We'll talk about the undue burden clause and the so-called fragile compromise. This balancing act can be seen in statements made by two of the politicians who were behind the ADA and who articulated economic arguments for the benefits of the act, as well as requirements of business. First, Steve Bartlett, who is a congressman, stated, quote, "ADA will empower people to control their own lives. It will result in a cost savings to the federal government. As we empower people to be independent, to control their own lives, to gain their own employment, their own income, their own housing, their own transportation, taxpayers will save substantial sums from the alternatives." So that's a clear statement of the benefits. Now, Senator Dale Bumpers, also a supporter of the act, was more explicit about not only the benefits, but also the costs. And he said, "We are obligated here to weigh the interests of the rights of the handicapped, which ought to be total, against what is obviously going to be quite a burden for a lot of small business people." These politicians attempted to maneuver between the arguments of business owners who were in opposition to the ADA in general because they feared that it would increase their costs, and the interests of society as a whole, where the cost-benefit argument for implementing the ADA is far more persuasive. To limit costs to businesses, there were three major features embedded in the ADA. First, as I stated before, a so-called undue burden clause was added, stating that owners actually don't have to make modifications if they are too expensive or difficult. And this basically applies to existing buildings more than new construction, since in new construction, on the one hand, one can easily make things like bathrooms, doors, and hallways big enough. One can design ramps or elevators that remove barriers between floors and so on. Since new construction must comply with the ADA, which is also embedded in modern building codes, a building code will simply not be issued, at least in theory, unless the building plans are in compliance. Now, existing buildings in general do not need to conform to modern building codes if they were in compliance with regulations that were in existence when they were built. The ADA is one of the few laws that actually require existing buildings to be modified and made compliant with current regulations. They can't simply be grandfathered under older codes. So the intent of the undue burden clause was in a sense to sabotage this requirement to allow certain buildings to remain non-conforming if the owner could make a case that doing so would cause a, quote, significant administrative or financial difficulty. And second, there was no enforcement mechanism built into the legislation. Existing buildings that are not accessible can remain that way indefinitely unless and until someone, a private citizen, brings a lawsuit against the building owner and prevails in court. But doing so was made more difficult because of a third feature of the ADA, which was designed to limit costs to businesses. And this third provision was a feature designed to limit financial incentives for litigation, the so-called fragile compromise, which allowed injunctive relief only. So what injunctive relief means is that any successful litigation may force a building owner to fix the problem, but cannot result in monetary awards for damages. Now, it's true that some states, California, New York, some others, actually do allow for monetary damages, providing more of an incentive to sue based on legislation that was passed at the state level. But the framers of the federal ADA specifically sought to prohibit that practice, thereby making it far more difficult to bring legal actions against non-compliant, inaccessible buildings. The New York Times article shown on the slide explains that most businesses will pay thousands of dollars to fix their bathrooms or install wheelchair ramps, not because it's the right thing to do, but because they could be sued for many thousands of dollars more for not having done it. This is a law that exists in the heavens, Leonard J. Davis, the scholar of disability studies, told me. It doesn't work unless you bring a lawsuit, end quote. And without giving lawyers a financial incentive to bring lawsuits by permitting awards for damages, many lawyers won't take on such cases pro bono. And most disabled citizens simply don't have the financial resources to take action themselves or pay for legal assistance. The article states that some small business owners think that such lawsuits brought under the ADA are a kind of scam, but that for disabled people, there really is no other option. The undue burden clause, the lack of an enforcement mechanism, and the so-called fragile compromise permitting only injunctive relief show how political and economic considerations have placed upper limits on health, safety, and welfare considerations with respect to accessibility and the ADA. In the next chapter, we look at the surprising trajectory of governmental regulations for the provision of light and air in buildings.